I had never met this defense attorney before, and here we were in court on an initial conference on my client's medical malpractice case. And he turns around and he asks me, listen, what do you need to settle this case? Would you like to know why that's a loaded question and why I had no ability to answer it at that time? Come join me for a walk near the water here as I share with you the answer to that question. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. All right, this was a medical malpractice case, and my client was claiming that her doctor was careless and caused her significant harm and injury. We were in court on what's known as a preliminary conference, which is basically a scheduling conference that is designed to go ahead and set up a schedule about when things will take place in this particular lawsuit. And when I say a schedule, it means when documents have to be exchanged, when the different witnesses, when the different parties have to be questioned as part of a pretrial process known as depositions. Lawyers also call it an examination before trial. So that schedule is voluntarily entered into by the parties, and now we submit it to the court for a signature, and that becomes a formal order. All right, but during this conversation, the defense attorney, who I had never dealt with before, turns around after we had agreed to different dates for scheduling on this particular case, and he says to me straight out, he says, listen, Gerry, what do you need to settle this case? Now, does that question mean that he has authority to go ahead and offer or settle this case right now? The answer is no. He has zero authority. He has no ability to go ahead and settle this case now. And if that's true, then why would he bother to see whether or not I have an idea or an opinion about what I need or what my client needs to settle this case? Well, I'll tell you, he's doing a bit of probing. He's doing a bit of intelligence work. He's trying to get detailed information, not just to see whether or not I have an idea or a range of what I think this case is worth, but he wants to know my reaction to that particular question. He will know that I know that he doesn't have authority. Now, it sounds like a comedy routine. He knows that I know, but he doesn't know. But no. It's not a comedy routine. Any attorney doing this for any length of time will recognize, and I've been doing this now for 37 years, will understand that when you first start the lawsuit, that question, what will you take to settle this case? What do you need? That question is a loaded question. And here's why. It's loaded because I, as the attorney who represents the injured patient, I have no possible way of knowing at that point whether or not my client's injuries are permanent. I have no way of knowing whether my client will require additional care and treatment into the future. I don't know at that point whether my client will require surgery to try and fix or repair any problem that she has. There is no possible way for me to know that information. This incident happened only a few months earlier, and she is continuing to receive medical care and treatment to address her injuries. So when they ask, hey, how much do you need to settle this case? The only time I could provide any type of an educated answer, an accurate answer, is when I know for sure that my client has been able to try and get the best medical care, and that now her doctors have told her that there is nothing else we can do for you, that there is no possible way that surgery will improve your condition. There is no possible way that any physical therapy or medication or any other types of treatments are going to improve your condition. You are going to be disabled. You won't be able to return to work. You won't be able to do your daily activities. At that point, now I can do a full analysis to determine what the true value of my client's injuries are. And then I can strategically go back to the defense and say, okay, I know that my client's injuries are really worth $2.5 million. So I'm going to go to the defense and I'm going to let them know that I need maybe $6 million to settle this case and that I'm willing to negotiate. In that instance, they will understand that my demand of $6 million is not absolute, it's not firm, and maybe if they're truly interested in trying to negotiate, maybe they will start to negotiate. But just because the defense attorney at the very beginning of the case turns to me and says, look, how much do you need to settle this case? It doesn't mean whatsoever that they have any interest in trying to settle the case at this point. Now, I'll share something else with you that's also very important. Just like I don't know at that point what the true value of my client's injuries are because of everything I've discussed with you, likewise, the defense has no way of verifying and they have no way of knowing whether or not what I am claiming assuming I give them a range or give them a number, is accurate. And so there would be no possible way for them to turn around and say, you know what? We agree with you. We'll give you that number. Have a nice day. That's never going to happen. They will not have obtained all of my client's medical records at that point. So they will not know the full extent of her injuries. They will not have had an opportunity to have my client's records reviewed by various medical experts who will then confirm or reject our theories as to what happened, as well as reject our theories of my client's damages. So all of that is still an unknown to them. Instead, they are much more likely to turn around and say, okay, I understand you don't have a range to tell me now. Why don't we reassess and have this conversation again during the course of discovery as we're learning more and more details, as we have an opportunity to question your client and learn in their own words, in her own words, exactly what happened and, importantly, what things she can no longer do today as a result of her injuries. And we also want an opportunity to speak to her treating doctors to see what they have to say. At that point, we would be in a better position, the defense would argue, to go ahead and accurately assess her real damages. Plus, it also assumes that they have reached the conclusion that the doctor whom my client sued, who they represent, truly was careless and caused my client harm and injury. So just because the defense attorney reaches out at the very beginning when we meet in court and says, look, what do you need to settle this case? It doesn't mean that he thinks his doctor was careless yet. It doesn't mean that any carelessness is associated with my client's injuries yet. And it certainly doesn't mean that I know the full extent of my client's injuries, and he certainly doesn't know it, and he certainly has zero authority, no authority, in which to actively negotiate and try and settle this case at this point. So why do I share this quick information with you? I share it with you because this happens from time to time, and it happened in this particular case, and it's remarkable and it's eye-opening to understand what that question really involves and what the attorney is really looking for when he asks that question, hey, how much do you need to settle this case now? You know, I recognize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you are thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.